In this episode, I would like to discuss about section 15 of the Indian Contract Act 1872, that is coercion. What is the definition of the coercion and what are the essential ingredients of coercion, and what are the consequences if the coercion is exercised. That means, if any contract is entered upon by exercising the coercion, what will be the legal consequence, whether the agreement will be valid or void or voidable, that is the topic of discussion today. Now, I would like to discuss about the definition of the coercion in accordance with section 15 of the Indian Contract Act. It says that coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code, or unlawful detaining or threatening to detain any property to the prejudice of any person with intention to cause any person to enter into the contract, and it is immaterial whether the Indian Penal Code is applied in the place where the coercion is employed or not. So, whether Indian Penal Code is applied or not, law will take its own course. So, let us have a look about the ingredients of the coercion, that is section 15, that committing any act forbidden by Indian Penal Code. So, committing any act forbidden by Indian Penal Code means Indian Penal Code 1860 defines various offences and various punishments are prescribed. Now, as an example, it can be said that if any person at the point of dagger or at the point of any gun threaten any person that unless you sign the paper or unless you enter into the contract, I will stab you or I will shoot you, and the person being threatened has signed the paper. So, that means it is the coercion, that means he has signed, that means he has consented, not voluntarily or freely, but there is the exercise of coercion. So, this is the instance of threatening. It may be relating to any of the offences as defined in Indian Penal Code, like it may be case of section 302, that is murder, or maybe that a person is threatening another person that unless you deliver me this object or unless you sign the paper or enter into the contract, I will fire at your house, that means I will set fire in your house. So, that is a kind of mischief. He is threatening that he will commit the mischief in respect of his property. So, it is coming under the purview of section 425 and 426 of Indian Penal Code. And similarly, if any person says that unless you sign the paper, I will beat you, that means he may cause the hurt or grievous hurt, that means it is coming under the 323 or 325 or 326 of Indian Penal Code. So, this, and also moreover in Indian Penal Code it is defined there, that is criminal intimidation by virtue of section 503, and the punishment is prescribed under section 506, that any person threatens to cause any injury to any person. So, coercion, it means that if any person has consented into the and thereby entered into the agreement, but the consent has not come voluntarily, he was induced by exercise of some threat or by unlawful detaining or threatening to detain anything, that it may be coercion. So, let us have a look about the second ingredient, that is threatening to commit any act forbidden by Indian Penal Code. So, first is committing any act, so it will also come, and second, threatening to commit any act forbidden by IPC. Next ingredient is third and fourth, that is unlawful detaining of property or unlawful threatening to detain any property. So, as for example, it can be cited that a person by way of bailment has delivered some goods to the bailee for some repair work is to be done. Now, the charges for such repair is, as for example, 500 rupees, but the bailee asks the bailier that you have to pay 2000 rupees, unless you pay 2000 rupees I will not restore your goods, and he was bound to pay 2000 rupees, but that consent is not freely coming out. So, that is the unlawful detaining of the property. So, if any person has come to his friend's house and kept there his two-wheeler or four-wheeler, and then the friend is claiming that unless you give me such money, I will not restore your commodity, scooter or four-wheeler, I will not return you, I will not allow you to get this. And thereby ultimately his friend forced him to sign the paper or causes him to enter into the contract. So the consent in this case has not come out freely, but there is the exercise of coercion, and that is why it is stated intention is to cause any person to enter into an agreement. So it is also sine qua non, that means most indispensable thing, that the object or intention should be to cause any person to enter into the contract. So if any person merely threatens another person that he will stab him, but there is no such agreement, then coercion is not attracted. Threatening any person for any cause, it may come under the purview of the Indian Penal Code undoubtedly, but that is not hit by section 15, that is coercion under the Indian Contract Act. Coercion always relates with the entering into an agreement, that means a person has threatened intending to cause any person to enter into the contract. And the last is, it is immaterial whether IPC or Indian Penal Code is in force or not where the coercion is employed. So it is not material that where the contract was induced by exercise of coercion, whether Indian Penal Code is applied or not. So whether Indian Penal Code is applied or not, law will take its own course, that means coercion will be considered by the court of law. Now I would like to discuss about the illustration given in the Indian Contract Act itself, that A on board an English ship on high sea caused B to enter into a contract by exercise of criminal intimidation, and afterwards A has filed a suit for breach of contract against B in Calcutta. Now criminal intimidation is punishable in accordance with Indian Penal Code defined in section 503, and punishment is prescribed under section 506. But in England that is not punishable, but still it is liable for coercion because by virtue of this section 15. That means though in England it is not an offence, and moreover 506 is not applied in the high seas or in English ship, and that is not applicable at the time and the place, but still it is hit by section 15 of the Indian Contract Act. Let us have a look that last ingredient was, it is immaterial whether IPC is in force or not where the coercion is employed. So illustration is given that A on English ship causes B to enter into an agreement by an act of criminal intimidation under IPC, Indian Penal Code, and A afterwards sues B for breach of contract at Calcutta. So this is coercion, though it is not an offence in England, and 506 of IPC was not in force at that time and place. So whether IPC is applied there or not in that place or at that time, but still it is hit by section 15, and if it is proved, the legal consequence will ensue in accordance with law. Now I would like to discuss about one landmark judgment of the Privy Council decided in the year 1912, that is Askari Mirza versus Bibi Jai Kishori. Now brief fact of the case is this, that a minor borrowed the money on the basis of two mortgage deeds, and then he agreed to a compromise decree, but later on the mortgages were declared to be void, because we know that minor's agreement is void ab initio, that means from the very beginning it is void. Then the minor took the plea that he was compelled to agree that compromise because he was threatened to be prosecuted for false representation of his age, that he is the minor. That means there is exercise of coercion. So as there was exercise of coercion, so he was constrained to come to the agreement that means compromise decree. So, he came to the compromise decree, means he agreed to the compromise decree because he was threatened to be prosecuted for misrepresentation of his age, and so it is hit by coercion. But court said that no, if the cheating is proved on the part of the minor, then the plea of coercion cannot be maintainable, and ultimately the case was sent for retrial. So, please let us have a look that Askari Mirza versus Bibi Jayakishori 1912 Privy Council decision. Gist facts are minor borrowed on 2 mortgage deeds and agreed to a compromise decree, and mortgages of minor were declared later on to be void, and minor took the plea that he was threatened to be prosecuted for false representation of his age, and so he agreed in compromise through that coercion. And court held that if the charge of cheating is true, then it is not coercion, and the case was ultimately sent back for retrial. Now, I would like to discuss about another important judgment, that is Chikam Amiraju versus Chikam Sesamma, decided in the year 1917. It is stated that if any person threatens to commit the suicide and thereby induces another person to enter into the contract, it is voidable because it is hit by section 15, because it is considered as coercion is exercised. We know that committing the suicide is not an offence because the person who commits the suicide is beyond the clutch of the law, but the attempt to commit the suicide is an offence. By virtue of section 309 of the Indian Penal Code, attempts to commit the suicide is an offence. So, if any person threatens the other that he will commit the suicide unless the other person agree into any terms of the contract, or that means he is inducing another person to enter into the contract by threatening that he will commit the suicide, it is a coercion and it is voidable. We know that section 309 says about the attempt to commit suicide is an offence, and moreover section 503 and 506 of the Indian Penal Code deals with the criminal intimidation. So, that a person, if he declares that he will commit the suicide in order to induce the other person to enter into the contract, that means he is giving the criminal intimidation, a threatening, and thereby induces the other. So, 309 and 503 and 506 are connected in this aspect. So, in this case it was decided, let us have a look that in Chikam Amiraju versus Chikam Sesamma in the year 1917, it is decided that threat of suicide to cause the somebody to enter into an agreement or execute a deed is coercion, and so it is voidable. Now, I would like to discuss about next case, that is Ashley versus Renault. What happened in this case, the plaintiff borrowed the money by pledging the goods, and it was agreed upon between the pawner and pawnee that ultimately 20 pound is to be paid by the pledger in order to redeem the pledged commodity, that is the plate. But at the time of making repayment, he paid up the 20 pound which was actually agreed upon, but the pawnee, that is pledgee, did not restore him the pledged plate. Now, he was claiming additional 10 pounds, and ultimately the pawner, that is the pledger, had to pay the additional 10 pounds in order to redeem the pledged commodity, that is the plate. So, court decided that the payment of additional 10 pound was by exercise of coercion, because it was actually agreed upon to pay 20 pound, but additional 10 pound was paid because he was constrained to make the payment, because otherwise there was no chance of redemption. So, let us have a look that Ashley versus Renault, the plaintiff pledged his plate to the defendant, the case of 1731, 20 pound was agreed to be repaid. Pledgee or pawnee insisted for additional 10 pound, plaintiff paid that to redeem the plate, and court said the delivery of extra amount, that is the 10 pound, that is through coercion. So, ultimately the additional payment of 10 pound was by way of coercion. It was decided by the court. Now, I would like to discuss about the next judgment, that is Karupai Ammal versus Karupia Pillai. It was decided in the year 1987 by Madras High Court, where Madras High Court held the distinction between Indian law and English law on the point of coercion. Now, in this judgment, it was distinguished in this way that there are some differences between the concept of English law and Indian law on the point of coercion. That is, according to section 15 in Indian Contract Act, the term is used as coercion, whereas in English law the term is used as menace or duress. And second is the concept of coercion, definition of the coercion under the Indian Contract Act, it is much more wider because it is covering the threatening as well as unlawful detention of the property, whereas under the English concept the only threatening is coming under the purview of the coercion. Unlawful detention of the property is not inserted in the definition, that is why it is narrow. Moreover, the Indian Contract Act definition of coercion is wider from other point of vision, that is, the threatening may relate with not only the contracting parties, but upon any other person, means threatening can be exercised against any person upon whom the contracting party is interested. So, threatening can be caused to him, that means the contracting party himself, or to some other person upon whom he may be interested. So, that means it is much more wider, whereas under English concept the threatening must be related with the between the contracting party, outsider or stranger is not inserted. So, in this way it is also a little bit narrower. And so far Indian Contract Act is concerned, in case of coercion, the threatening is not necessary to be very immediate, that means instant threat is not necessary. It may be a threat which relates about the future circumstances, that means something may happen after future, means in near future it may be, whereas in case of English concept of coercion the immediate or instant threat is necessary. So, let us have a look there, means in this judgment, as I have said, that Karupai Ammal versus Karupia Pillai, it was decided in the year 1987 by Madras High Court, that there is coercion under Indian law and the coercion under English law, there is the distinction. Now, first is under the Indian law the term is used as coercion, whereas under English law it is used as menace or duress. Second is its definition is much more wider because the threatening and unlawful detaining both are inserted, whereas under the English law its the definition is narrow because only actual or threatened violence are inserted, but not unlawful detention. And third is it can be exercised not only upon contracting parties, but also upon other persons or strangers. So, its application is much more broader, whereas under the English law only upon the contracting parties, so its application is comparatively narrow. And finally, that is immediate violence is not necessary in case of coercion under the Indian Contract Act, whereas immediate violence is necessary in case of coercion under the English law. So, this distinguished points, that means a distinction is made by this judgment between the concept of coercion of English law and Indian law. Finally, I would like to discuss about the effect or consequence of coercion. So, if any agreement is induced by exercise of coercion, then what will be the legal consequence, whether the agreement will be valid or void or voidable. So, if we want to know this thing, we have to consider some other sections related with section 15. As we have already came to know that section 15 of the Indian Contract Act defines the concept of coercion, but other sections will give the answer about the consequence. Consequence is not mentioned in section 15 itself. So, if the coercion is exercised, then the question comes that whether the consent is caused freely. That means we know that free consent is very much sine qua non, that means the indispensable things for making the contract valid. So, section 13 defines what is the consent, that means two or more persons are said to give consent when they agree upon the same thing in the same sense, that section 13 says. Section 14 is related with it because 14 defines what is free consent. In section 14 it is stated that a consent is said to be freely given if the consent is not induced, either exercise of coercion or undue influence or fraud or misrepresentation or mistake. So, if the consent is induced by coercion, then what will be the consequence? That is answered in section 19 of the Indian Contract Act. Section 19 says that if the contract is induced by exercise of coercion, then the contract is voidable at the option of the party whose consent was so thereby caused. So, if the coercion is exercised in order to induce any person to enter into the contract, as a consequence the contract will be considered as voidable at the option of the party whose consent was so thereby caused. So, let us have a look that section 15 defines the coercion, whereas section 13 defines the consent. Consent is defined as I have stated. Section 14 discusses about free consent, and section 19, that is voidability of the agreement without free consent. So, in section 19 it is stated that it is voidable at the option of the party whose consent was so thereby caused. So, this is the concept of coercion and its effect on the contract.